Okay, well, listen, if you don't tell me how you got this information, then you and I are gonna have some problems.
This is one of the absolute craziest things I have ever seen in court, and not in a good way. A Georgia judge has ordered a lawyer representing rapper Young Thug to spend the next 10 weekends in jail after finding him in contempt of court. Why? Because the judge had a secret meeting with the prosecutor and a witness and might have tried to coerce the witness. But we don't know for sure because the judge held a secret ex parte hearing without the defense present. That's not something you should do. When the defense lawyer, Brian Steele, inquired about the secret meeting, the judge got upset. Not about the meeting, but that someone snitched. As a result, Mr. Steele will go to jail with his client. Literally, he asked that he be able to be incarcerated with his client. That is so freaking metal. But how did we get here? Well, Young Thug, whose real name is Jeffrey Lamar Williams, is one of the biggest rappers to emerge from Atlanta's rap scene in the early 2010s. He's known for upending the traditional rules of rap using malleable vocal styles that include inflections and mumbles. His style blends elements of rap with trap, hip-hop, and R&B. Now, Young Thug first broke through with his mixtapes, 1017 Thug and Barter 6, and in 2019, his first studio album, So Much Fun, debuted at #1 on the Billboard 200. His most popular songs include Stoner, Danny Glover, Best Friend, and The London featuring J. Cole and Travis Scott. He has a record label called Young Stoner's Life. Now, in addition to being a boundary-pushing artist, Williams has faced some groundbreaking legal challenges as well. He and 5 other men are on trial in Atlanta in a sprawling criminal case. Prosecutors allege that Williams is one of the leaders of a street gang called Young Slime Life, or YSL. The indictment says that YSL is a criminal street gang that started in late 2012 in the Cleveland Avenue area of Atlanta, Georgia. YSL claims affiliation with the National Bloods gang. During opening statements, Fulton County Deputy District Attorney Adrian Love said, quote, "The members and associates of YSL moved like a pack with Jeffrey Williams as its head." Prosecutors claim Young Slime Life is involved in a range of criminal activities, including drug trafficking, murder, armed robbery, carjackings, and other violent crimes. The most serious allegation against Williams is that he rented a car that was used to murder rival gang member Donovan Thomas Jr. in 2015. Now, the Georgia Racketeer Influenced and Corrupt Organizations Act, or RICO, is typically used to target organized crime, and is currently being used to prosecute Donald Trump in Georgia. However, in practice, prosecutors use it to prosecute people participating in conspiracies that don't involve traditional mobsters. Williams and his co-defendants were indicted under Georgia's version of RICO. The state law was enacted in 1981, about a decade after the original federal RICO statute. And it's generally easier to convict someone under Georgia's RICO statute than in the federal statute. In part, it's because the law is expansive, but also has actual definitions. Georgia Code Section 1614-4 states, quote, "It shall be unlawful for any person employed by or associated with any enterprise to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity." So a prosecutor must prove enterprise, pattern of activity, and racketeering activity under the Georgia RICO statute. And Williams is accused of conspiring to violate the Georgia RICO Act and participating in gang-related activities. And all that's interesting because the Williams trial started in January of 2023 and has been a wild ride with lots of controversial moments. Williams says that YSL is just a reference to his record label, and his lawyers argue that although there is a street gang known as Young Slime Life, it's not as violent as prosecutors allege, and that Williams isn't associated with it. And the prosecutors in the trial have cited several of his songs and lyrics as evidence, arguing that they demonstrate his involvement in criminal activity and his leadership role in the YSL gang. And the indictment claims that his songs are an overt act in furtherance of a criminal conspiracy. This is obviously controversial, and it's not unusual for artistic expression to include references to violence, but prosecutors are arguing that lyrics offer an insight into the gang activities and criminal intent, which is right out of a Key and Peele skit.
Stroke my chin real slow when I'm lying, and I was laughing super hard as Darnell was dying.
But that brings us to the present drama. Fulton County Superior Court Chief Judge Ural Glanville has ordered defense attorney Brian Steele to spend the next 10 weekends in jail after finding him in contempt of court. This decision came after Steele refused to disclose how he learned about a meeting between the judge, prosecutors, and a prosecution witness. Steele challenged the judge in open court, stating that he'd been informed of a meeting in the judge's chambers that happened that morning. And according to Glanville's order, quote, during the proceedings in the above-styled case on the afternoon of June 10th, 2024, one of the 2 representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex-parte communication which took place in the court's chambers that morning. The only parties present for this ex-parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's orders. Now, I guess that is technically an accurate description of what happened, but that only scratches the surface of the insanity. First of all, ex parte is a Latin phrase meaning on one side only, by or for one party. So an ex parte hearing is one where not all parties are present. And generally speaking, if anything happens in court, all the parties should be present. That seems obvious. And an ex parte communication occurs when a party to a case or someone involved with a party communicates directly with the judge about issues in the case without the other party's knowledge. Now, judges are generally not allowed to have these private conversations in matters pending before the court, or which can reasonably be expected to be filed in the court, except when all parties or counsel are present. And second of all, generally, the judge is not allowed to inquire into how an attorney learned of anything. Attorney-client and work product privilege exist, as well as the Fifth Amendment, and probably would have protected the attorney here, especially without a subpoena from the judge, if the judge even has subpoena power. But let's dig deeper. Now, we're going to look at the actual video of what happened in court, but first let's talk about the witness at issue here. Ken Copeland is a key witness in the trial. During opening statements, the prosecution said that Copeland was the triggerman in the murder of Donovan Thomas in 2015. Thomas was a rival gang leader who also worked in the music business. Prosecutors alleged that Young Thug wanted him dead because he was trying to lure rapper Rich Homie Quan to sign with Young Thug's label. And Copeland was not named in the indictment. He was originally charged with the Thomas murder, but the state dismissed the charges. However, he didn't enter into a plea agreement with the prosecutor requiring him to cooperate in exchange for immunity. So when the prosecution called Copeland to testify, his lawyer, Jonathan Melnick, told the judge that his client would invoke his Fifth Amendment right not to incriminate himself. So prosecutors quickly offered Copeland immunity, and Judge Glanville dismissed the jury and informed Copeland that he would not be prosecuted for his testimony. So whatever he said would not incriminate him. The judge informed Copeland that he would go to jail if he refused to testify. The jury came back in, but Copeland then invoked his Fifth Amendment. The judge said, quote,
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time.
Now, this is where things get even stranger. Prosecutor Adrian Love accused Melnick of conspiring with the prosecutors to stop Copeland from testifying. Melnick was not happy with that accusation. He told Love he would report her to the bar.
So what we are seeing, we believe, is tampering with witnesses. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with.
Now, defense attorneys for Williams and the other 5 defendants told the judge that they suspected the state knew Copeland intended to plead the Fifth, but they put him on the stand anyway, so he was forced to do it in front of the jury. The judge denied their motions for mistrial. On the next day of trial, Melnick had flown home because he had a non-refundable plane ticket, so attorney Caleb Bumpus was in court to represent Copeland. Although the trial was scheduled to begin at 9 a.m., it was delayed until 11:30. That's when Brian Steele approached the lectern and said he'd been notified that the judge held a secret meeting with the witness, Bumpus, and prosecutors in the judge's chambers.
And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
To which the judge replied,
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too.
Steele said he had heard a prosecutor tell Copeland he could be jailed until all the cases against all the defendants in the indictment were completed. Quote,
If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
Now, if you're accused of Georgia RICO, you'll probably want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you or a loved one is suffering from mesothelioma, lung cancer, or pleural disease, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, or just about anything else, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. Now, Now, state court rules prohibit ex parte communications. Rule 4.1 says, quote, except as authorized by law or by rule, judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending proceeding. It further states that the only exception to this rules are as follows. Quote, where circumstances require ex parte communications are authorized for scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in a case called Arnau versus Arnau, the Georgia Court of Appeals said that, quote, ex parte communications are presumed to have been in error. In that case, the appellate court reversed determination of visitation rights in a divorce case because the judge had an ex parte meeting with an expert psychologist after the trial had ended, but before his ruling. Quote, although Mr. Arnau had the opportunity to cross-examine Dr. Berlin during the trial, he was denied the opportunity to cross-examine the witness with respect to any opinions he offered during the post-trial meeting with the court or to respond to any new allegations or other evidence which may have been presented to the court. Ms. Arnau argued that the psychologist didn't offer any new evidence during that meeting and only summarized his prior testimony, but that was still unacceptable to the court. Quote, furthermore, even if such a showing had been supported by the record, the fact that ex parte communication is merely cumulative would not make the consideration of such evidence harmless error. Ex parte communications are presumed to have been in error. Now, Mr. Steele has already appealed, and in the emergency motion for supersedious bond, Steele said, quote, I demanded information regarding the meeting, including the names of everyone who was present, requested a transcript of the proceedings, and made a motion for mistrial on the grounds that an improper ex parte hearing was conducted with a sworn witness, Kenneth Copeland, which violated Mr. Williams's constitutional and statutory rights, including the right to due process and a fair trial. Now, going slightly backwards in time, in court, Judge Glanville denied Steele's motions and found him in contempt. The order of contempt cites Georgia Code section 15-1-3, which says, quote, every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. And the judge found that Steele had violated the section of Georgia Code that states the court has the power to, quote, compel obedience to its judgments, orders, and process, and to the orders of a judge out of court in an action or proceeding therein. Now, I admit I'm at a loss as to what the judge possibly could have been doing here, but Jack Meltzer at SCOTUS Places came up with an interesting theory that might be applicable here. Under Georgia Code, a prosecutor can seek an order compelling a witness to testify in a criminal trial where they have been given immunity. That's pretty standard. But under Supreme Court of Georgia case law, arguably a criminal defendant doesn't have a right to be present when the prosecutor is seeking an order to compel testimony. But that particular case, King versus Georgia, is based on the idea that the defendant doesn't have a right to object to the compulsion of testimony, and therefore it doesn't matter whether the defendant is there or not. And that might be so, and maybe the judge was operating under that assumption, but that seems very different from the situation that we're dealing with here. And even if true, that doesn't mean that the state has an interest in keeping all of this secret after the fact. So what order did Steele disobey? Well, he refused to tell the judge how he had learned about the ex parte meeting. Now, judges have wide latitude to manage attorney conduct, but that doesn't necessarily mean that Steele had to disclose his sources. The Georgia Rules of Professional Conduct, which govern lawyers, says, quote, a lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent. And comment 5 explains, quote, the attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. So yeah, this means that whatever a lawyer learns during the course of representing a client is confidential and protected by privilege. So you would think that Steele cannot be compelled to give up his source, maybe even against a court order. And generally, to even be held in this kind of contempt, the conduct or statements need to interfere with the running of the trial itself. And Steele's appeal says that, quote, his statements and conduct did not interfere with or pose imminent threat to the preservation of order and decorum in the court or interfere with the orderly processes of the administration of justice, as evidenced by the fact that the court was able to continue the trial after its initial oral pronouncement holding Mr. Steele in contempt. Further, Mr. Steele's refusal to disclose the name of the individuals who informed him of the ex parte meeting, which he argued would constitute a direct violation of his duty of confidentiality imposed by Rule 1.6, in no way delayed or impacted the underlying trial. Moreover, any doubt must be resolved in favor of Mr. Steele's vigorous advocacy on behalf of his client, especially when he was raising serious concerns about the court's involvement in an ex parte contact with a sworn witness. Steele arguably had a right to know what Copeland said in chambers. And as defense attorney Andrew Fleischman pointed out, the things that Copeland said to the judge are admissible as evidence. Georgia Code section 24-6-622 says, quote, "The state of a witness's feelings towards the parties and the witness's relationship to the parties may always be proved for the consideration of the jury." Now, the state insinuated that the defendants threatened Copeland not to testify against them. Megan Cuniff, who writes the blog Legal Affairs and Trials, reported Copeland's backstory. Quote, "In a federal gun case from 2018 implies he took a machine gun in a pillowcase to a recreation center as an act of self-defense. As this court is aware, there were approximately 14 attempts on the lives of Mr. Copeland and or his family members leading up to his arrest in this case, according to the memo from October 17, 2018. It is these attempts and his discussion with law enforcement surrounding these attempts that led him to the decision to possess the firearm at issue." Okay, so what if Copeland was threatened by the defendants or YSL gang members? Well, that still wouldn't give the judge the right to have an ex-parte meeting with the witness. The defense lawyers can't be excluded from those conversations. But Andrew Fleischman said, quote, "In the most sympathetic reading possible, there was a threat to the witness and he wanted reassurance that he'd be safe, but defense counsel still gets to hear that. If a threat keeps a witness from testifying, the state can claim the defendant forfeited the right to cross. So there are other ways the court can handle threats to a witness." But the judge ordered Steele to serve 20 days in the Fulton County Jail by spending the next 10 weekends there.
All right, counsel, I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends.
But in a move that will surely be recounted in lawyer cocktail parties for decades, Steele requested to serve his time in the Cobb County Jail, where Williams is being held to continue working on the rapper's defense.
I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you, and sir. I will, sir. If that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
Not surprisingly, Steele and his law firm immediately filed an appeal against the contempt order with the Georgia Court of Appeals. Steele argues that the judge was wrong to assert that the meeting was confidential because there was no court order ruling that any matter involving Copeland was confidential, and of course couldn't have been confidential because there was a third party there. And after Steele's arrest, 20 to 25 lawyers from the Georgia Association of Criminal Defense Lawyers appeared in court on Steele's behalf. Ashley Merchant, the defense attorney who discovered Fonnie Willis's affair with Nathan Wade, argued that Glanville should sua sponte, or on his own, transfer the contempt case to another judge because he's a witness to the contempt. And that's almost certainly right. The judge can't be impartial in his own case. But the judge impatiently tells her that Steele won't disclose his sources, and that's why he's in contempt of court.
If the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about anything that was said. I just want to know who it was.
In this clip, Merchant tells the judge that since it's a direct criminal contempt charge, Steele has due process rights.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
The judge said that he had already given Steele all the due process he's going to get on the spot.
Criminal contempt is different. It is on the spot.
Merchant argued that Glanville can't compel Steele to reveal confidential communications.
Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And this goes back to whether Judge Glanville had a right to ask Steele to disclose the confidential information without a court order. Merchant then explains that the issue is whether or not a hearing needs to be held right now. She contends that he's a witness to the proceeding, and it has to be referred to another judge because he's a witness. Judge Glanville asked Merchant to show the case law, and that's what she does.
Do you have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older.
But Judge Glanville rejects those cases because he thinks they're too old. The most recent case is from 1994. But as Merchant pointed out, there aren't many cases involving lawyers being held in direct criminal contempt. Merchant cites In re Adams, where the Court of Appeals overturned a direct criminal contempt charge against a lawyer where, quote, the trial court made the summary contempt finding without providing Adams with notice of such intent at the time the court scheduled the hearing thereon, and without providing him with an opportunity to be heard or to be represented by counsel before summarily finding Adams in criminal summary contempt of court. And that case supports Merchant's argument that in direct criminal contempt finding, the judge has to hold a hearing and allow the lawyer to present witnesses and cross-examine the other witnesses. But Judge Glanville is not done disciplining people in his court. In a Tuesday order, Glanville asked Fulton County prosecutors, witness Lil Woody, real name Kenneth Copeland, and the witness's attorney, Kayla Bumpus, to appear in a June 25th hearing and show cause for why they, quote, should not be held in contempt for disclosing information from the ex-party conversation to members of the defense counsel. But wait, there's more. There is so much more. Defendant DeMonte Kendrick filed a motion for the judge to recuse and attached an affidavit from his lawyer, Douglas Weinstein. The affidavit alleges stunning acts by the judge and the Fulton County prosecutors. During the meeting, according to the affidavit, Copeland allegedly said, quote, he would sit in jail for 2 years rather than testify, and the prosecutors allegedly told Copeland that if he lied, they would not prosecute him. Quote, Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. One of the assistant district attorneys, either Hilton or Love, said, quote, there were over a dozen defendants left to try. After these threats by the judge and the prosecutors, Copeland relented and said he would testify. The affidavit says Judge Glanville printed out a copy of the perjury and making false statement statutes. Boy, that's pretty ironic given what happens next. And Copeland also allegedly said he would testify that he did murder Thomas. Quote, ADA Hilton and told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. So apparently the judge intends to hold a hearing to find the people who allegedly leaked all this information to the defendants. Now, luckily, the Supreme Court of Georgia stepped in and granted the supersedious bond, so at least Steele won't be going to jail while we sort all of this craziness out. Even though Steele would have dined out on that for years. But it will be interesting to see what happens to the precipient witnesses of this ex-parte hearing, what happens to the lawyer, Steele, and inevitably whether there's going to be a mistrial, because there are going to be lots and lots of motions for mistrials. The bottom line is that Brian Steele made a motion in good faith about a meeting that should not have occurred without the defense present, and he's being thrown in jail for it. And if you're a lawyer and the judge sends you to jail, there's probably not much you can do. But if you're a lawyer or anyone else that deals with contracts, today's sponsor, Spellbook, will help you a ton and maybe keep you out of jail. Because Spellbook uses AI to review and suggest language for your contracts and legal documents right in Microsoft Word, helping you write and analyze entire contracts and documents holistically. You can draft, redline, and review contracts 10 times faster with AI. And the insights it provides me as I'm reviewing and writing documents is absolutely shocking. Now, I'll let you in on a little secret that only real lawyers know. No one starts a contract from scratch. We're always cribbing from other sources. But Spellbook is a huge time saver, whether you're a lawyer or just deal with contracts or legal documents in your job. Spellbook is trained on huge case databases, form libraries, and statutes, which means it can suggest accurate and relevant language for almost any legal document. Spellbook can draft entire documents from scratch, which are ideal for one-offs, and it can automatically build a searchable library of your most used legal language, so you can easily reuse your favorite clauses. You can use the chat prompt to give it almost any task you can think of, including generating automations for documents. And if you're analyzing a contract, which is what I usually do, it'll generate insightful comments and revisions. I plugged the latest contract I was negotiating into Spellbook, and it immediately identified a bunch of really important issues. It found contradictory clauses, missing terms, and non-defined terms. My favorite is when it pointed out that at one point the contract said 90 when it meant 90,000. Whoops. And Spellbook suggested additional clauses and ways the client could protect themselves from various situations. It found several, too many, potentially unenforceable terms, including a ridiculous penalty term, and one clause that, quote, might be considered overly broad and could potentially be challenged in court as it restricts the party's freedom of speech for a period extending beyond the term of the agreement. Yeah, that's not staying in the contract. It even suggested business-related revisions like the right of first refusal that would hamper future engagements. Now, obviously, it can't know everything about a contract or a case. You'll still need to adjust the clauses to your liking and still need to analyze everything. But it's a fantastic starting point. So whether I'm writing a contract or litigating one, I think my first step from here on out is going to be plugging that document into Spellbook. So click on the link below for a free 7-day trial and a 15% off discount to Spellbook. Spellbook has been a massive boon for any kind of legal writing, and now you can try it for free today. It saves me a huge amount of time and makes any legal document better. So click below for a free 7-day trial and an exclusive 15% off of a subscription. After that, click on this link over here for more Legal Eagle, or I'll see you in court.